Sinabi mo din, Ms. Mago, while you were testifying, you were tested positive with COVID-19. Is that true?
Yes po.
And because of the overwhelming pressure that you got and the intense scrutiny, it had a detrimental effect on your mental health. Is this correct?
Yes po, Your Honor.
Did you see a doctor?
I had no chance po.
Why did you say that it had a detrimental effect on your mental health? It's all right.
Opo. Well, when I was positive po for COVID, I manifested the signs and symptoms po, especially yung dry cough. And it gets worse every day. But I do inform naman po yung City Health Office. Nakakausap ko naman po sila every day and they monitor. And also, dahil nga po dun, nagkaroon ng decline in my physical health first. And then, ongoing nga din po yung mga investigations at that time. And especially the hearing last September 2021 at the Senate Blue Ribbon Committee po, I was really traumatized by what happened, and it really had a negative impact on my mental health po.
Thank you, Ms. Mago. I will now switch my questioning, Mr. Chair, to Yusek Lau, if he's still present.
Yusek Lau, please answer the questions.
Present, Mr. Chair.
Good morning, Yusek Lau.
Morning po, Mr. Chairman.
Did you have any chance hearing so far the testimony of Ms. Mago, who is now appearing before us?
Yes, Mr. Chairman.
She experienced tremendous pressure.
As a lawyer, despite being a lawyer, I also experienced tremendous pressure, Mr. Chairman.
Notwithstanding the fact that you are a lawyer and probably trained in answering questions, but you yourself experience the same environment that she did. Am I correct to assume that?
That is precise, Mr. Chairman. In fact, I made a statement in the last hearing of the Congress, House of Representatives, and in the Senate that I felt that the testimonies elicited to my person during the time were under pressure, and I feel that the environment in the Senate was hostile, considering that the questions were very misleading and that being shouted and upon, first time in my life being berated as to my person, as to my profession as a lawyer, as to my education, as to my character. In fact, even the family name which was passed on to me by my ancestors, which I shall pass on to my children, has been berated, being called as Lau Lau. That's very hostile, Mr. Witness. It's my first time, even as a lawyer, that I've been treated that way.
So you share the sentiments of Ms. Mago?
Yes, Mr. Chairman, because before the Senate hearing started, I was even interviewed by a news agency, which I stated that the Senate and the House of Representatives hearing during the time, I was very interested in participating to shed light on the circumstances, but I never in any of my wildest dream would foresee how I will be treated in such a hearing, Mr. Chairman.
Ms. D.S. Marcoleta, your time is up, but Congressman Acosta Jr. of 3rd District of Palawan has yielded his time to you. So you have another 20 minutes.
Thank you, Mr. Chair, and thank you to my colleague. Attorney Lau, I'm wondering why you did not go to the Supreme Court in order to protect you against the kind of harassment or intimidation or the undue influence. You were made to answer under duress. Sometimes you have been scolded. And like what you testified today, you have a recourse in the courts of law. I'd like to believe that you're familiar with the case of Bengson versus Senate Blue Ribbon Committee. Are you familiar with that case?
Yes, Mr. Chairman.
And in that case, Yusek Lau, there were two petitioners. They were actually witnesses summoned by the Senate Blue Ribbon Committee to appear before them. But instead of testifying, they went to the Supreme Court via a petition for prohibition. And they succeeded. The Supreme Court ruled in their favor because it was decided that the inquiry was based only on the privileged speech of then Senator Juan Ponce Enrile, which did not contain any suggestion of a contemplated legislation. That is why the court ruled in favor of the petitioners, kaya hindi na sila tumistigo. Why did you not go to court and seek the same remedy?
Initially, Mr. Chairman, before the first hearing and before the second hearing of Senate, I was of the impression that the intention of the Senate investigation was in aid of legislation. And as one of the key personnels who handled the procurement of the PPEs and the test kits, it was wise that we could shed light on what should be done to make better measures for the succeeding procurement of the country. However, during the first hearing and the second hearing, things did not turn out the way we expected it to. We were treated after the second hearing. After the second hearing, Mr. Chairman, I wanted to go to the courts. However, when I was about to buy a ticket for Manila and make some arrangements there was already a statement released that I was planning to abscond the Philippine territory because I was in hiding. That prompted me to be concerned because if I ride the plane and arrive in Manila airport, I might be viewed or projected as planning to leave the Philippines, Your Honor. So, and I was also afraid that I will be arrested, Mr. Chairman.
But do you know that in the case of Ong versus Court of Appeals, GR number 132839, this is dated November 21, 2001. It says, the rules of procedure of the Senate and the rules of the Blue Ribbon Committee do not state that the Blue Ribbon Committee has the power to issue an order of arrest. Did you know about that?
I am not aware about that, Mr. Chairman, but I am very aware that I have the right to freedom of speech, right to liberty, right to privacy, Mr. Chairman. However, during the Senate investigation, I was threatened all the time by legislatures that I will be cited in contempt, that I will be sent to jail and detained, Your Honor.
Kaya nga, ngayon sinasabi ko na sa iyo, sinabi sa kasong ito that was decided by the Supreme Court, not even the rules of procedure of the Senate of the Philippines, including the rules of the Blue Ribbon Committee, wala silang power na mag-issue ng order of arrest. What they can do is to go to court and ask for an order of arrest. Ganun kasi ang sistema ng ating pamahalaan. Even the National Prosecution Service, kahit ng ating mga piskalya, hindi naman silang nagpapa-aresto. Not even the Department of Justice can do that. They will have to go to court and ask for an order of arrest. Ito maliwanag. Wala naman silang kapangyarihan na magpa-aresto ng tao. Hindi ko nga alam kung bakit meron silang na-detain ngayon, kung paano nila inaresto. Dapat sana ay gumawa ka na ng paraan, pumunta ka na sana sa korte, sapagkat ang nangyayari, hindi na nga in aid of legislation. Alam mo ba yung Attorney Lau, are you still there?
I am present, Mr. Chairman. Still here, Mr. Chairman.
Familiar with the case of Neri versus Senate Blue Ribbon Committee?
I'm not aware, Mr. Chairman.
Okay. In this case, pakinggan mo lang mabuti, ano? In this case, the Supreme Court held that the Senate's power of inquiry shall be used to obtain information in aid of legislation and not to gather evidence of a crime, which is essentially prosecutorial, not a legislative function. Sinabi pa niya ganito, no matter how noble the intentions of the respondent committees, in this case Blue Ribbon and other committees joining them, they cannot assume the power reposed upon our prosecutorial bodies and courts. The determination of who is or are liable for a crime or illegal activity, the determination of who should be hailed to court for prosecution, and the task of coming up with conclusions and findings of facts regarding anomalies, especially the determination of criminal guilt, are not functions of the Senate. Congress is neither a law enforcement nor a trial agency. Maliwanag ba sa iyo yun, Attorney Lau?
Very clear, Mr. Chairman. Thank you for the education, Mr. Chairman.
Kasi ang Senado hindi isang prosecutor's office. Yan ay nasa province na ng National Prosecution Service natin. Kaya nga meron tayong NBI, meron tayong fiscal. At saka yung dapat malaman mo rin ito, you have the right to privacy. You have the right to invoke the right against self-incrimination. In the case of Ople versus Torres, 293 SCRA 141, the Supreme Court had the opportunity to discuss the independent constitutional right to privacy as explicitly recognized in Section 3, Paragraph 1 of our Bill of Rights, and its other facets in Section 1, Section 2, Section 6, and Section 8 of the Bill of Rights. Ito yung dapat ay tiningnan mong mabuti kesa naman pinayagan mo yung sarili mo na mag-isa ka doon. Sa tingin natin ay hindi na nga in aid of legislation. Pero pang isa, Yusek Lau, although it is an American jurisprudence, in Marshall versus Gordon, ito tandaan mo mabuti ha, nagkataon lang naman na ganun yun, talagang case ito eh. In Marshall versus Gordon, 243 U.S. 521, 1916, it was held that congressional contempt power not expressly conferred by the Constitution was implied for efficiency and power, but not as a means for punishment of private matters. Did you understand that, Attorney Lau?
I understand that clearly, Mr. Chairman. Thank you, Mr. Chairman.
And you should also be apprised of this. Under Section 18 of the Senate Rules of Procedures governing inquiries in aid of legislation, and under Section 6 of the Rules of the Blue Ribbon Committee, a vote of the majority of all members are required. Let me repeat that. A vote of the majority of all members are required in case of citing in contempt. Did you know that the Blue Ribbon Committee can cite you or anybody appearing before them with only two people agreeing? Number one, the chairman and any other member. And that is against their own rules. Did you notice that, Attorney Lau?
I noticed that, Mr. Chairman. It was repeated multiple times as a threat to my person.
Okay. Do you think sa ngayon na habang nagpapatuloy ang investigation sa Senado, meron na bang nakalap na evidence that any official or employee of PSDBM had anything to do with the kind of accusation or allegation that they have been getting in subjecting the employees of Pharmally into this prolonged questioning and inquiry? Meron na bang kasangkot na mga public officials, particularly with PSDBM?
None, Mr. Chairman. Despite 7 or 8 hearings already conducted by the Senate, there has been no established proof of that. Only insinuation, Mr. Chairman.
More particularly on the issue na may binabanggit sila na merong switching of certificates, merong switching of production dates. Did they in any way establish that any employee might have been involved? I mean, public employee or officials of PSDBM? Was there an indication that somebody conspired or aided or in cahoots with the kind of allegation that they are now trying to elicit in their prolonged and continuing investigation?
No, Mr. Chairman.
Okay. The reason why I am asking these questions, because if you will review the rules of the Blue Ribbon Committee, sinasabi nila doon that in the course of their investigation, if they uncover evidence of misfeasance, malfeasance, and nonfeasance, they will refer it to the Ombudsman, to the DOJ, and any other investigative agency as the case may be. Kung totoo man, halimbawa, ipaghalimbawa na natin na meron na silang nakalap na ebidensya, all of them are saying that they have built up a strong evidence. O bakit naman hindi pa sila pumunta sa Ombudsman, Mr. Chair? O sa DOJ, sapagkat nandun naman sa kanilang tuntunin yon. Hindi nila ginagawa because they are building up a case, Attorney Lau. That is going beyond formal inquiry and investigation in aid of legislation. Investigations cannot be done to build up a case. This is the province of the prosecution service of our government. Do you understand that, Attorney Lau?
I understand fully, Mr. Chairman. That's how I was also educated in law school, Mr. Chairman.
Yun na, kaya nga sa iyo ko particularly sinasabi ito. Sayang naman kasi kabisado mo yung batas, abogado ka naman, para hindi ka na sana na-traumatize kagaya ni Ms. Mago. Si Ms. Mago, we can understand na na-traumatize siya. Hindi man siya preparado sa ganito, lalong-lalo na kung pagtatanungin mo naman sa environment na parang nananakot ka pa. Mahirap talaga yun. Kahit tayo, mga lalaki na nga eh. Kung,
Diaz Marcoleta, your time is up, but Congressman Evcas gave his 20 minutes to you, so you have until 1 o'clock, 1:05.
Salamat po, Congressman Evcas. Bagamat hindi na rin siguro masyadong magtatagal ang pagtatanong ko, pero salamat din po at binigyan pa niyo ako ng pagkakataon. Yun nga, ang sinasabi ko, Mr. Chair, tayo, kahit malaki na tayo, lalo na po kayo, Mr. Chair, talagang malaki naman ang bulas nyo, lalaki naman kayo talaga, may hirapan din tayo kung hindi mapaghandaan naman, hindi ibigay sa atin ang kondisyon na kung saan malaya at voluntaryo tayong makapagsasalita. If the environment was concocted in such a way that they will be able to extract from you any information even under duress or even under undue influence. Napakahirap naman po, kagaya ng nangyari kay Miss Mago na sunod-sunod na pagtatanong. Miss Mago, can I go back to you? What is the difference between our way of questioning, our way of extracting answers from you, compared to the manner of questioning and the conditions under which you were placed when you appeared before the Senate Blue Ribbon Committee?
Your Honor, personally po, from my experience,
Pwedeng pakilakas mo, ma'am?
Apo. Personally po, from my experience, Your Honor, dito po sa House of Representatives, ang questions is isa-isa lang po. Tapos pinapakinggan po kami, pinapatapos po kami sa aming mga sagot. And although strict din po yung investigation, wala pong atmosphere of pressure, and also wala rin sumasabat during the time na sumasagot kami per question po, Your Honor.
Mga katwid, pwede naming i-assume dito, Ms. Mago, na yung isinagot mo sa amin, voluntaryo, walang halong pananakot na ibigay mo ng malaya, hindi kagaya nung ikaw ay tinanong sa kabilang chamber na kung saan pati sagot mo, sabi mo nga dito, is a pressured response.
Yes po, Your Honor.
Importante kasi sa atin yon, Ms. Mago, sapagkat ang ating mga batas ay talagang pinoproteksyonan ang lahat ng tao makapagbigay ng malaya, totohanan, at walang kapaimbabawan na sagot. Sapagkat ang ating pinag-uusapan ngayon ay may kinalaman hindi lamang sa pondo ng ating pamahalaan, kundi may kinalaman na rin doon sa katotohanan na gustong malaman ng ating mga kababayan. Ang pagsasagawa kasi ng ganitong uri ng inquiry, Ms. Magos, para sa inyo na rin kaalaman, 4 na bahagi kasi ito eh. Formal inquiries and investigation in Congress, in either chamber, can be done and for purposes of, number 1, in aid of legislation, kasi maaaring ang sagot na makuha namin sa iyo makatutulong sa amin sa pagbabalangkas ng mga batas na makakabuti sa atin. Pangalawa, yung oversight function na kung saan ay tinitingnan namin kung yung implementation ng batas na ginawa namin ay nagagawa sa maayos at naayon doon sa objectives. Pangalawa, yung constituent function, sapagkat meron din kaming pananagutan sa mga constituents na nag-aakala na ang aming ginagawa ay para rin sa kanilang interest. At yung pang-apat, yung tinatawag nating teaching function. Sapagkat umaasa ang kabuuang mamamayan ng ating bansa makaalam ng totoo. Importante kasi na dapat kung ano yung lumabas, yung totoo lang. Narinig mo yung sinabi ng chairman namin. We are only in search for truth. Ironically kasi, Ms. Mago, kung titingnan mo yung Blue Ribbon Committee, meron silang insignia doon eh. Isa sa nakasulat doon, aside from the word Blue Ribbon Committee, ay yung salitang Latin yun, Mr. Chair eh. Whatever. Pero pag tin-translate mo sa English yun, Madam Ms. Mago, and the truth shall set you free. Yun naman ang totoo. Yun ang hinahanap natin eh. Kaya ka pumunta rito, ang aming assumption, and that was the expectation, the chairman of this committee, is for the truth to set us free. Did you understand that?
Yes po, Your Honor. Thank you for that information din po.
Mr. Chair, salamat po.
Thank you, Congressman Marcoleta. Is Lincoln Ong present? Hello, Lincoln. Mr. Lincoln Ong.